It depends. So there are two parties that are involved in this, and that's why it depends. If you're in a personal Chapter 7 and you have a vehicle, then the Chapter 7 trustee appointed to the case has an interest in what's going on, and if you owe money on the car, the creditor in question has an interest in what's going on. So let's first start with the Chapter 7 trustee's interest in the car. When you go through a Chapter 7 bankruptcy, the big picture goal is just to erase debts in one fell swoop. The whole process typically takes between 5 and 6 months from the day you file the petition until the day the court grants you a discharge. And then once you get that discharge, those debts that are of the dischargeable variety are just wiped out without you paying a dime. So from the creditor's perspective, since this is a bit of a hit, they would like to have limitations. And so the law gives some limitations. One such limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in the Chapter 7 bankruptcy. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own or have an interest in. And all of those assets are divided into two categories, exempt and non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed to the case to seize and liquidate and have money to distribute to the creditors. We determine whether something's exempt or non-exempt by appealing to one of two exemption tables. That's the scheme that we have here in California. One table is for homeowners with equity, the other is for everybody else. Now, each table has a list of various categories of possessions. Some categories have dollar limits, others have no dollar limits, and our goal as we're listing the assets is to stick them into these categories so that they're protected from the depredations of the Chapter 7 trustee. Anything we can exempt is yours to keep. Anything we can't exempt, the trustee takes. What about cars then? Well, they're assets, and the dollar amount that you have, because the car exemption does have a dollar limit, depends on which table you're in. We have to exempt the equity in the car, not necessarily the total value of the car, but the equity, defined as the current market value of the car minus the amount you still owe on the car. So we add up all the equity you have in your cars, and if that dollar amount is less than the exemption amount, the Chapter 7 trustee will take no action against the cars. But if it's more than that, then the trustee will typically give you a choice. You can either give the car to the trustee will sell it, write you a check for your exemption amount, and use the rest of the proceeds to cover the cost of sale and to have money to distribute to creditors. Or you can buy the equity back from the trustee by making, typically a trustee will let you make payments, say, over 6 months. And you can buy that equity back, that non-exempt portion of the equity. You can work things out with the Chapter 7 trustee. But I said that there are two interested parties here. If you are making payments on the car, there's a creditor who has an interest in what's going on. Because after all, if you don't make the payments, then outside of bankruptcy, the creditor can take the car back and liquidate it. And if there's a post-resale deficiency, come after you to collect the post-resale deficiency. But if you go through a Chapter 7 bankruptcy, well, that personal liability on the debt goes away, so that if later on you lose your job, you can't make the payments, the creditor repossesses and sells for less than you owe, you don't owe anything. So the creditors paid a lot of money to Congress. Oh, it does bespeak some corruption there, but welcome to the real world. And they got the law changed so that now if the creditor wants to, it can insist that you resurrect your personal liability on the vehicle debt by reaffirming the debt. And there's a mechanical procedure involving a reaffirmation agreement that you have to sign, the judge has to approve. And if you go through that, then the personal liability has been resurrected. But more to the question here, in a Chapter 7, If you're behind on the payments, the creditor may take the position, we're really not interested in you pretending that you're going to be able to cure this pre-petition arrearage. We want to get the car back. And the creditor may simply ask the judge to lift the automatic stay so that it can repossess the vehicle, or maybe wait until the bankruptcy case is completed and then repossess the vehicle. But there's a situation where unless you're current on the payments, you may end up losing the car in a Chapter 7 bankruptcy. So long-winded answer to what sounded like a simple question, but when a lawyer says it depends, it generally does depend, and there are several cases that you have to consider.